India Legal presents Courts Roundup.
Hello, I am Disha and you're watching Courts Roundup. In this program, we bring you the latest legal and details of court proceedings. Before we begin, here's the headline. Supreme Court upholds the UP government decision increasing cut-off marks for 2019 recruitment of 69,000 Shiksha Mitras. Aggrieved Shiksha Mitras may compete in the next recruitment examination. Allahabad High Court seeks response of the central and UP government in Habeas Corpus plea filed in quashing of proceedings initiatives against two social activists apprehended by the Mathura Police while on the way to meet Hathras rape victim family. Supreme Court directs the centre to hasten the process of pending appointments to vacancies in the National Green Tribunal, gives a deadline of 4 weeks. Bombay High Court directs Maharashtra government to shift under trial Varavara Rao from jail to Nanavati Hospital for 15 days for a thorough checkup.
India Legal presents Courts Roundup.
The Supreme Court has upheld the Uttar Pradesh government's decision increasing cut-off marks for 2019 recruitment of 69,000 Shiksha Mitras. The Supreme Court dismissed the appeal filed by Uttar Pradesh Shiksha Mitra Association in a case related to the recruitment of 69,000 assistant teachers in the state of Uttar Pradesh. A bench headed by Justice U.U. Lalit further recorded the state's contention that the Shiksha Mitras would be given one last chance to compete in the next recruitment examination, and the modalities of the same would be discerned by the state.
The Supreme Court has upheld the Uttar Pradesh government's decision regarding cut-off marks for 2019 recruitment of 69,000 Shiksha Mitras or assistant teachers to 65 and 60 for the general and reserved category respectively. The Apex Court affirmed the Allahabad High Court judgment in this regard and dismissed the appeals filed by Uttar Pradesh Prathmik Shiksha Mitra Association, giving green signal to the UP government to fill the 37,000 Shiksha Mitra vacancies in terms of the results of the recruitment exam announced in May 2020. The Apex Court, however, held that aggrieved Shiksha Mitra would be given another opportunity by allowing them to compete in the next recruitment examination. The top court left to the state government to work out the modalities with regard to the same. The judgment was rendered by a division bench of Justices U.U. Lalit and Mohan M. Shanta Gaudar in the plea challenging the decision of Uttar Pradesh government fixing the cut-off marks for recruitment of 69,000 assistant teachers in 2019.
कि बीएड को एनसीटी ने, हमने नहीं, एनसीटी ने जून 2018 में बीएड डिग्री धारकों को भी अलाउ कर दिया भर्ती में शामिल होने का। तो भर्ती में अचानक 2.5 लाख लोग एक्स्ट्रा और आ गए, इसलिए कट ऑफ ऑटोमेटिकली ऊपर चला गया और इसमें कुछ भी मतलब हमारी तरफ से किया हुआ कुछ भी नहीं था। कि नेचुरल, जिसे कहते हैं ना, कॉमन सेंस, रैशनल एक लॉजिक थी।
The bench had reserved its verdict on July 24 after detailed hearing which lasted for over 2 days. The Uttar Pradesh Prathmik Shiksha Mitra Association had challenged the UP government's order of January 7, 2009 by which the qualifying marks for the assistant teacher recruitment examination of 2019 were increased. This notification increasing the cut-off marks was issued a day after the exam for the recruitment of 69,000 teachers in primary schools of the state was held. The Allahabad High Court had confirmed the state government's decision clearing the way for recruitment of assistant teachers in basic education council schools in the state. The petitioners contended that fixing the qualifying marks at 65 and 60 was arbitrary and the same should have been fixed at 45 and 40. They pointed out that the qualifying marks for the assistant teacher recruitment exam in the previous year was 40 and 45. Moreover, it was also their case that the qualifying marks were fixed before the conduct of exams in the past and not after the exam as was done in 2019. It was argued before the two-judge bench that as per Anand Yadav judgment, Shiksha Mitras were entitled to be given 2 consecutive opportunities for recruitment as assistant teachers and were also entitled to weightage for experience at the time of final selection. Appearing for the petitioners, senior advocate P.S. Patwalia had submitted that the teacher eligibility test qualified Shiksha Mitra constituted a separate homogeneous class. Further, the Uttar Pradesh government has been given the go-ahead by the Apex Court to fill the remaining 37,339 posts of assistant teachers in line with the results announced in May 2020. These posts had been kept vacant by the June 9 order which had stayed the selection process in the state. Bureau Report.
The Supreme Court has asked the Union Ministry of Environment, Forest and Climate Change to expedite the appointments to the National Green Tribunal that are pending before the Union Cabinet. The court has asked the ministry to see whether a decision on these appointments can be taken within 4 weeks. The bench of Justice A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna, while hearing a plea filed by the NGT Bar Association Western Zone seeking expeditious appointments to fill up vacancies at the tribunal. Appearing for the centre, Additional Solicitor General N. Venkatraman told the court that all appointments after being cleared by the Intelligence Bureau are now pending before the Appointments Committee of the Union Cabinet. Counsel for the petitioner pointed out that the appointments of expert members have been pending before the Appointments Committee since September this year. During the last hearing, the court took note of the appalling situation with regard to the present strength of the NGT and had directed the centre to notify all existing vacancies at one go, including the ones likely to arise in the next 6 months. The court was informed by the centre that a notification for filling up 9 vacancies at the NGT would be published by the end of July. Further, until new members are appointed as against the vacancies, existing member of the NGT who are likely to retire shortly shall continue to hold office, the court had ordered. Maharashtra Governor Bhagat Singh Koshyari has moved the Supreme Court challenging the issuance of notice by the Uttarakhand High Court in contempt of petition filed against him for not paying the market rent for a government bungalow allocated to him when he was Chief Minister of the state. In his plea, Governor Koshyari has stated that since he is the sitting governor of Maharashtra, the bar under Article 361 of the Constitution of India cannot be ignored while issuing notice in a plea seeking contempt action against him. Article 361 affords protection to the President and Governor of states against legal action before courts. It states, the President or the Governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the power and duties of his office or for any act done or purporting to be done by him in the exercise and performance of those power and duties. By way of background, in June 2020, the Uttarakhand High Court struck down a law brought in by the state government to validate the free occupation of state-provided bungalows by former chief ministers and the illegal expenditure incurred on that account over a 19-year period. The act had been brought about to undo the effect of May 2019 judgment passed by the High Court, whereby the ex-chief ministers were asked to vacate bungalows that they continued to occupy free of cost despite their terms having come to an end. At the time, the court had also directed that the former chief minister pay market rent for the term of their illegal occupation over a 19-year period. The Supreme Court has reserved its verdict in a plea by former soldier of Border Security Force Tej Bahadur challenging the election of Prime Minister Narendra Modi to Lok Sabha in 2019 from Varanasi. A bench of Chief Justice of India CJI S.A. Bobde and Justices A.S. Bopanna and V. Ramasubramanian rejected repeated requests by the petitioner to adjourn or pass over the matter and proceeded to hear the case, stating that the case has been lingering on for a long time and is too important a matter to be deferred. Tej Bahadur had challenged the rejection of his nomination as Samajwadi Party SP candidate from Varanasi constituency for Lok Sabha 2019 election. Bahadur had initially filed his nomination as independent candidate but had later altered it to enter his nomination as SP candidate. His nomination papers were reportedly rejected by the returning officer, citing his failure to submit a certificate that he was not sacked from BSF for either corruption or disloyalty. Dismissal on the grounds of corruption or disloyalty attract ban on contesting elections. Bahadur challenged this rejection, contending that such a decision was taken to facilitate an easy victory for Prime Minister Narendra Modi. It was Bahadur's case that the returning officer failed to note that he had produced his dismissal letter while filing his nomination paper. The dismissal letter, Yadav claimed, clearly showed that he had been dismissed for alleged indiscipline and not for corruption or disloyalty to the state. Therefore, there was no requirement for any additional certificate to prove that he had not been dismissed of corruption or disloyalty. He had submitted. Bahadur was dismissed from BSF in April 2017 after a video captured by him on mobile phone went viral, in which he complained about the poor quality of food provided to soldiers. He then approached the Supreme Court in February 2020 by way of the present appeal.
मेरी डिमांड इतनी सी थी कि इलेक्शन आरपी एक्ट में इस चीज़ का प्रोवाइड है कि जब आप किसी को नोटिस दोगे उसके कैंडिडेचर के रिजेक्टिंग के लिए, तो रिटर्निंग ऑफिसर 48 घंटे से पहले स्क्रूटनी नहीं कर सकता है। इसके रिगार्डिंग चीफ जस्टिस ने कहा कि आप हमें डॉक्यूमेंट दिखाओ। हमने उनको पूरा एक्ट प्रोवाइड किया है। एक्ट में मैंने सारा चीज़ दिखा दिया है, जिसमें लिखा गया है कि डे वन बट नेक्स्ट डे बट वन, जिसका मतलब होता है डे आफ्टर टुमारो। दैट मीन्स 24 घंटा से ज़्यादा हमें टाइम दिया जाना चाहिए एज पर रूल, एज पर स्टैचू। चीफ जस्टिस ने इन सारी बातों को सुना और सुनने के बाद ऑर्डर को रिजर्व कर लिया।
The Amitabh Bachchan star Arjun will not be released for the time being after the Supreme Court has declined to lift the stay granted by the Civil Court and Telangana High Court against the release of the movie. A three-judge bench led by Chief Justice of India S.A. Bobde dismissed the appeal by producer of the movie. Super Cassettes challenging an October 19 order of the Telangana High Court restraining the release of the movie in India and abroad. The petition had raised an important question concerning copyright law in India, with a true life event of a real person which are already in public domain can be considered property which can be bought and sold, and whether the same will be entitled to copyright protection. The appellant, Super Cassettes Industries Private Limited, known as T-Series, had claimed that the movie is based on the real life of football coach Vijay Barse, who is portrayed in the film by Amitabh Bachchan. Hence, it was submitted. The High Court was wrong to grant an injunction against the release of film on the assumption that there is copyright infringement in the life story of one Akhilesh Paul, who was the captain of the Indian slum soccer team coached by Barse. The litigation was initiated by the independent filmmaker Nandi Chinni Kumar, who claimed that he had purchased the right to make a movie about the life of Akhilesh Paul. Further, with a view to avoid any scope for potential legal issues, the character of the team captain in the film was deliberately fictionalized so as to exclude any identity with Paul, the plea added. Delhi High Court has refused to interfere with the order of the Delhi government wherein a ban has been imposed on the public celebration of Chhath Pooja. While dismissing the petition, the division bench of Justice Hima Kohli and Justice Subramaniam Prasad noted that public gatherings such as these one would act as a super spreader of the infection. The order has come in a plea challenging the order of the chairman of the Delhi Disaster Management Authority to prohibit public gathering on the day of Chhath Pooja, that is November 20th. In that order, puja celebrations near ponds and river bank have been prohibited in light of the pandemic. While holding the petition to be devoid of merit, the court said, in today's day and time, such as petition is belied by the ground realities. Delhi High Court has refused to provide relief in an appeal filed by Ashok Arora against the order of the single judge, wherein his plea seeking a stay on his suspension from Supreme Court Bar Association was rejected. The division bench of Justice Rajiv Sahai Yendlo and Justice Asha Menon has refused to interfere with the observations of the single bench of Justice Mukta Gupta in its order rejecting the original plea. Earlier, while refusing to provide relief, the single bench of Justice Mukta Gupta had noted that Ashok Arora failed to establish a prima facie case in his favour. On 8th May, the Supreme Court Bar Association had suspended its secretary Ashok Arora with immediate effect after the Executive Committee took this decision in a meeting. By this resolution, it was also decided that Rohit Pandey, the Assistant Secretary, will take over the roles and responsibilities of the Secretary. On 5th of June, SCBA issued a notice to Ashok Arora to show cause as to why ex-party proceedings by a 3-member committee should not be initiated against him for alleged imputation laid out in the notice. The Kakaduma Court has granted bail to a man in 2 cases related to the Delhi riots, while observing that the investigation in the case against him left a lot to be desired. The additional session judge Amitabh Rawat was hearing the bail plea of an accused Ajay. It was submitted that due to the riots in Delhi, many FIR were registered at different places and accused was falsely implicated because the FIR have shown different places and accused cannot be involved in these cases at the same time. It was also argued that he is in custody for more than 5 months. It was submitted that there is no evidence, no public witness and no CCTV footage against the accused. The court noted that the case against the accused was registered on the complaint of complainant Gulfam, who stated that some unknown person had burnt his. Thus, the court noted that complainant is not an eyewitness to the incident. Importantly, the court noted that as per a witness statement, Ajay was arrested from near Neetnagar railway line bushes, but as per the arrest memo, the location of arrest is Jyoti Nagar police station. The court also noted that witness statements was recorded on 18th of April, but the incident was from 25th February. Consequently, the bail application under Section 439 CRPC of accused Ajay stood allowed and he was admitted to bail subject to furnishing personal bond in sum of Rs 20,000 with one local surety. Taking note of the critical medical condition of 81-year-old under trial Varavara Rao, the Bombay High Court directed that he be shifted to Nanavati Super Speciality Hospital from Taloja Jail for 15 days for a thorough checkup. A division bench comprising of Justices S.S. Shinde and Madhav Jamdar said ultimately the man is on almost deathbed. He needs some treatment. Can the state say no? We will treat him in Taloja. The bench further directed that he should not be discharged from the hospital without informing the court. The medical reports have to be submitted before the court. Also, the family member of Rao should be allowed to meet him at the hospital. The court will next consider the matter on 3rd of December. The public prosecutor, Deepak Thackeray, informed the bench after taking instructions from the government that the state of Maharashtra has no objection to shifting him to Nanavati Hospital, but the prosecutor submitted that the case should be treated as a special case and not as a precedent. The court was hearing 2 cases, the bail application filed by Rao on medical ground and the writ petition filed by his wife Hemlata saying that his incarceration was violation of his right to health and life during physical hearing of the matter. The Allahabad High Court has issued notices on a habeas corpus petition filed by three alleged PFI member arrested by the Deputy Superintendent of Police while they were going to Hathras to meet family of the deceased gang rape victim. The bench of Justices Pritinka Divakar and Dr. Yogendra Kumar Srivastav has issued notice to the central government, the state of UP, Superintendent of Jail, District Jail, Mathura and Prabal Pratap Singh. The court has listed the matter concerning release of Atikur Rahman, a student, Alam, a cab driver, and Masood, an activist, for hearing on December 14, 2020. It is contended therein that the accused petitioner, being concerned social activists, were going to meet the bereaved family and offer them consolation. Further, Alam, being a taxi or cab driver, was ferrying them to the said destination. However, they were detained on October 5, 2020 in Mathura while they were on their way. On Friday, a local court in Mathura rejected their bail pleas. The Kerala High Court has dismissed a PIL petition seeking a CBI probe into the aircraft mishap at the Kozhikode International Airport, which took place in August this year, killing 19. A bench of Chief Justice S. Manikumar and Justice Shazi P. Shelley dismissed the petition. In its judgment, the bench pointed out that an investigation into the probable causes for the mishap was already ongoing. Party in person Yashwant Shenoy had moved the High Court seeking an independent court of inquiry under the Aircraft Investigation of Accident and Incident Rule 2017 to study the functioning of the airport. Additionally, he prayed for investigation by the CBI into the aircraft tragedy itself. He claimed that the airport was constructed and operations carried out in violation of international and domestic norms. In view of these contentions, Shenoy further demanded the immediate closure of the Kozhikode airport, among other relief. Dismissing the petition, the court pointed out that an aircraft accident investigation bureau had already been set up, which the petitioner had not raised specific objection to. The only reservation the petitioner had raised was in respect of one of its members. In his petition, the petitioner does not demonstrate his reason for having such reservations about the member, the court observed. Well, that's all in Court's Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.